Hello, we are
Nurja Lisbeth.
and Hang Henny, and as a part of our final activity in this subject, we are going to show you how to search and quotate a case with small information, and after that we will outline the content and therefore also the problems in reference to the relevant norms of that case.
In our second part, we will show you which skills we acquired through this semester in class, and at the end of our presentation, we will do a critical reflection about the course.
The first step to do a presentation about a case is to find it. This is one of the skills we acquired in class, and now we are going to show you the easiest way to do so.
The given information about the case was ECG Calanque. With this information, we knew that this is a case of the European Court of Justice, and the name Calanque had to be an involved person in the case.
Our first step was to go to the website of the University of Valencia and to enter the libraries. After doing so, we pushed the button Database, which led us to the official diaries.
Once on the BOE website, we entered the legislation section. Knowing that the case belongs to the European Court of Justice, we entered the official database of the European Union.
After finding the searching area, we only could enter the name Calanque because we didn't have the case number and neither the date of the case. With this information, we were able to find necessary information to quotate a case.
The case C-450/93 of the European Court of Justice of the 17th October of 1995 deals with a dispute between a German graduate engineer of gardening and landscaping and the city of Bremen about the interpretation and applicability of a national law which is about the equality of men and women in the public service, and his compatibility with Article 2 of the European Directive 76/207 of the 9th of February of 1976 to the implementation of the principle of equal treatment between men and women in access to employment, vocational training, and promotion. The application of this national law by the city of Bremen was the main reason why the engineer was rejected in the promotion of a higher job.
The background of that dispute was the situation of two workers, Mr. Calanque, the prosecutor, and Mrs. Giesma, who got the job, who applied for the promotion of being the section manager of the Parks Department. Both of them had the same qualification and they also worked in the same subject area before. After the management of the Parks Department suggested the promotion of Mr. Calanque, probably because he always has been the representative of the section manager, the staff denied his promotion. After a further suggesting in favor of Mr. Calanque, the arbitration committee decided to choose Mrs. Gieselmann in respect of the clause in the aforementioned national law, paragraph 4 LGG.
This clause says that in the case of employment's transmission of a working post and in the promotion, women have to be primarily considered in the areas in which they are underrepresented, and only if they have the same qualification. Mr. Calanque did not agree with the application and therefore complained with the statement that this law is not legally compatible with the constitution of the state of Bremen, the country of Germany, and also not with civil law.
The first two instances dismissed the legal action so that the German Supreme Court had to decide about that case. The Supreme Court rightly held the opinion that the decision about the case depends on the applicability of the national law. After the Supreme Court agreed with the promotion of Mrs. Gieselmann because of the facts of same qualification and the underrepresentation of women, he declared the compatibility of the national law with the relevant statutes, Mr. Calanque stated.
Nevertheless, the Supreme Court had doubt about this decision and therefore submitted two questions to the European Court of Justice about its applicability. Both of the questions were aimed to clarify the derogation of Article 2.4 of the European Directive 76/207. As the conclusion of that, the European Court of Justice decided to answer both questions together regarding whether the applicable national law is compatible with the mentioned directive.
While speaking about the directive, Article 2.1 says that there can't be any discrimination because of the sex. Therefore, the European Court of Justice said on the one hand that in national law, the direct preference given to the woman in the mentioned situation is a discrimination of men. On the other hand, they recognized the derogation which consists in not disturbing the advancement of the equality of chances of man and woman to compensate the obvious inequalities which exist nowadays. In short, the relevant paragraph 4 of the directive serves the purpose of measures which may look discriminating, but in reality they are not.
After pointing out this fact, the European Court of Justice pointed to another case of the 13th of December of 1984 to implement the women's rights, which highlighted very accurately that the applicable legislation cannot go above all factual inequalities between women and men. Furthermore, it is said that the Article 2.4 is just a derogation of the individual right of Article 1.1 of the directive, and it has to be interpreted narrowly.
Such a national law which gives absolutely and necessarily preference to the woman in such cases just exceeds the borders of Article 2.4 and also doesn't help the promotion of the equality of chances. To end up, it's shown that the national law which leads to the fact of same occupation and work for man and woman, the result to which the Article 2.4 of the European Directive should have led. The case can be quoted as the following. European Court of Justice, 17th of October 1995, case number C450/93.
Now we're gonna explain the different things we learned in the subject. First of all, in lesson 1, we learned how to learn law, and we learned what it means to be a lawyer and also which features a lawyer has to fulfill in order to be a good one. Furthermore, we learned the generalities about the University of Valencia, how to handle things in the aula virtual, and the system of the library. We also got to know resources for the researching of law.
In lesson 2, we learned about the legal career of a lawyer. At first, we wrote an essay, and therefore we learned all its necessary criteria it has to fulfill, how to do a real curriculum vitae, and also how to prepare for oral presentations.
Lesson 3 consisted in understanding law. We had to learn to know legal terms, and to continue with the first lesson, we got to know the sources of legal information, the legal system, and its processes. And for this reason, we visited La Ciudad de la Justicia. To end up with the lesson, we learned how to read legal texts.
In lesson 4, we learned how to do legal research. We learned how to, and particularly the easiest way to find cases and laws like we already showed in this video.
And on lesson 5, we worked on our writing skills. We learned how to cite a case, how to structure an essay, and to continue with what we did in lesson 2, we had to work once again in our essays.
In lesson 4 and lesson 6, finally, we learned about the oral skills. We had a very extensively demonstration of the different important features you have to respect in your speech, the structure of your speech, and therefore we had a visit of a guy who already did his final exam and explained us the strategy of an oral presentation. After telling you about what we've learned in the subject, we want to do a critical reflection of the course, and because we agreed in nearly all points, we do it together.
At first, the subject was a little bit boring because we had the feeling that we knew all the information and already heard them all before a lot of times. But after a while, we had to do other activities, also in groups, which we didn't do before. With more time, we learned how to write an essay, how to do legal research for different courts and cases, and how to do oral presentations, which was very good because the skills are important for lawyers in their career.
Besides the content, we did a lot of activities to bring things closer to us. A few of them was not so great for me, but only because in the first month here my Spanish was very bad. Nevertheless, I want to emphasize that the possibilities and the continuous assessment of this subject offer a very good background understanding of what the students will become and what is necessary besides the theory.
Regarding this point, we want to say that at the visit to La Ciudad de la Justicia and also the visit from the student to show us the importance of a good oral presentation have been the best activities in class.
To come to what we expect of our marks, we uploaded all exercises we had to do, always have been to the activities which were obligatory. Besides this fact, we answered all multiple choice tests in the internet during the semester and think that we did it well. Therefore, we hope to get an 8.